So thanks everyone for joining us today on what is our third contentious clinic. It's super exciting as our contentious clinics have been born out of our IDR network, which is our IDRM for short, our online referral and support space. The contentious clinics take place each month, where the IDR team will come and present on various topics within the world of contentious probate, not just providing you with information, but also actual tips and takeaways that you can go away and use in your day-to-day. So they've been a real hit so far. So really excited that everybody's joining today and continuing to join each month. Today, we have Richard Thomas, who is a partner at IDR Law, and Sophie Brackenbury, one of our associates. They will be taking a look at the world of mediation, in which they'll be sharing their experiences and how to prep for a successful mediation. So I'd just like to hand over to Richard now, who will be taking us through the presentation with Sophie. And at the end, we'll come back and have any questions. If you can just add to the chat, then we'll address them at the end. And yeah, off we go.
Thanks, Lindsay. Hello, everyone. Thank you very much for giving us your lunch time. And we'll try not to be too dull and get through it so you can crack on with your sandwich or whatever else. So today, Sophie, as I say, is a very good associate here at IDR Law. I'm a partner, and we're just going to do a little bit about mediations. A lot of this is going to be opinion. So if this isn't law. It's not set in stone, and we can possibly agreeably disagree with certain things, but we thought it'd be really useful to go through what we find useful in terms of preparation. So what we'll be covering today, four parts. First, why mediate and when. Second, which is what I always think, it's so much of a successful mediation is in the preparation, and not being blindsided on the day, or not getting to the event itself and realizing that you can't do X, Y, and Z, or you don't know this, so you can't possibly settle, etc. Part 3, on the day itself. Obviously, you can never quite tell what's going to happen on the day. It's voluntary. The other side may come at you with something that you've not particularly thought of, but there are things I think that you can do on the day, or look, tips and things that we found. Again, you might have your own, but just something that we can share. And if we've got time at the end, we'll look at very briefly sibling rivalry, why that makes it slightly harder. And the things that you've got to be potentially more aware of in terms of dealing with a sibling rivalry case. Often the sort of preparation in the day itself is no different. It just can add some kind of emotional fireworks and sort of difficulties that I'll run through quickly. And then at the end we'll do questions, and then Lindsay's got some solid BD, some marketing chat at the end about the RDRN, which, joking aside, is a fantastic resource for people to use. So moving on to part 1, which will Sophie will take us through mainly. I'll pass you over to Sophie now.
Thank you. Thanks for that, Richard. I just wanted to kind of introduce it a little bit in terms of mediation. I think most of you on this webinar today will be quite familiar with mediation generally, but I think we've got a real mix of kind of contentious and non-contentious attendees. So I just wanted to just very quickly just remind us all of what it is. So it's a form of alternative dispute resolution, ADR, and it involves instructing an independent third party, a mediator, who attends with the parties and helps them facilitate a resolution if and when possible. So why do we do it? Well, there's many reasons, but let's start with the obvious. It's in the CPR, it's in the civil procedure rules, the practice direction on pre-action conduct and protocols, and you can see there at paragraph 8, which obviously sets out litigation should be a last resort. As part of a relevant pre-action protocol or this practice direction, parties should consider whether negotiation or some other form of ADR might enable them to settle their dispute without commencing proceedings. So as it says, litigation should be a last resort. There's an obligation on all the parties to consider ADR and a settlement throughout the proceedings. And one of the reasons why you would see a heading in a decent letter for action, which involves ADR, So paragraph 9, parties should continue to consider the possibility of reaching a settlement at all times, including after proceedings have started. Again, you know, throughout the whole process, really. So some people think it's just the case that, you know, if you've issued court proceedings, that you can't engage in mediation, and that's then that the opportunity is lost, and it's not the case. We often agree stays in the proceedings to enable us to facilitate mediation. Paragraph 11, if proceedings are issued, the parties may be required by the court to provide evidence that ADR has been considered. A party's silence in response to an invitation to participate or a refusal to participate in ADR might be considered unreasonable by the court and could lead to the court ordering that party to pay additional court costs. This is the one that usually gets people's attention. Obviously, the courts are willing and ready to penalise parties who unreasonably refuse to engage in mediation, and we've seen you know, the courts using those wide-ranging discretionary powers in terms of costs to apply indemnity costs to people, to parties who have unreasonably refused. And that's even in the case where a party thinks they've got a particularly strong defence or a strong case, sorry, or a strong defence, and believes that, you know, they will be successful at court on the day. Still, the courts have imposed sanctions, so that's a good enough reason for me. So there's other advantages as to mediation and why it's a good option, which you can see on this slide. So in terms of comparing it to court, you know, going to court is a long, complex, drawn out process, and often we see that our clients might be, you know, quite happy to go on engage in the court process, and they quite quickly can get litigation fatigue because they don't really realise how complex and stressful it can be. It's inherently risky, you know, going to court. These things often turn on the evidence of individuals on the day and the judge on the day, which makes it inherently risky. And we've all been there where you know, our clients stand up as witnesses and say things that we weren't quite expecting. So, you know, that's the risk in going to court. Touched upon it being very stressful. I'm sure majority of you would agree that it's stressful giving evidence or, you know, attending a court hearing for our clients. And, you know, we are dealing with, in the work that we do, we're dealing with families, and once you kind of engage in the court process, it can often mean that any relationships, any resolution is gone, and it's not just the individuals involved, it's, you know, the impact on the wider family members too that people need to consider. So costs. Going to court, I'm sure we've all had those conversations with our clients about how costly it can be, and you know, there's obviously no guarantee of success and no guarantee of recovery of those costs. Mediation is subject to privilege and is confidential, so obviously we can disclose information in mediation which we wouldn't necessarily disclose in open correspondence, and it means that, you know, the parties involved can say things that they wouldn't want the judge to know or hear, and that means that often it leads to more success, because people can get their views out and air their concerns, etc. Flexibility, the parties have more of a control with mediation, so in terms of the outcome, in terms of many elements of it, to be honest, but in terms of the outcomes, you know, if for example we're dealing with a will challenge, and we're successful with that will challenge, and the court, you know, the result is that will is void, and if it's an intestacy situation, then it might be that only one person inherits the full estate, or a couple of people, and that actually might not be what everybody wants. So we've got more of a degree of flexibility in terms of what we can agree with mediation. And then, you know, the parties get to have that feeling of having their day in court without having their day in court, so they can air their issues out, as I've touched upon, and they feel like they've been heard, and they feel that it's all come to some kind of a head and a conclusion. So that can be really helpful and kind of cathartic, because it's obviously the things we're dealing with are personal. Are there any negatives? Well, it's not cheap to go to mediation, but compared to going to court, it's much cheaper if it's a success. There's no guarantee of it being a success, of course, but then there is no guarantee with anything going to court. Is it likely to succeed? Well, I mean, in my experience, and I'm sure Richard will confirm this as well, but my experience is yes, I've had very high rates of success when it comes to mediation, for all the reasons that I've kind of set out already. Now that we've got access to remote mediations and hybrid mediations, there's more of an option for people to get to mediation, to attend, which makes the more chance of it being successful. I'll come on to that slightly later. But also, even if mediation isn't successful, in my view, it's not necessarily a full loss. We've often heard what the other parties, points are, and we've heard kind of what their the position that they're willing to settle on is, and their bottom line, and we've often narrowed some of the issues, so that usually acts as a springboard for further settlement discussions, and it's always useful to just get an understanding of the other side's position. And if nothing else, if you have engaged in mediation, then you can't be it can't be that you've been reasonably refused. So if nothing else, it gives you that cost protection. So what type of mediation should you go for? Old school, remote, or hybrid? Well, to be honest with you, COVID's had a big impact on this. Before COVID, I don't think everybody was quite set up for the remote world that we now live in, obviously, as we all know. But mediation's been one of those that I certainly was quite dubious and skeptical about how that would work in terms of being remote. But now all the mediators, everyone certainly that I've worked with, are set up for it. And actually, it's sometimes the default position, because particularly when we're dealing with the types of things that we deal with, where you've got, multiple parties, executors, various beneficiaries, charities, and different people all have their legal representatives, and you might have counsel involved. You've got a lot of people who need to be in one place at one time, which can be very difficult. Where we often have dealing with people around the world, so you've got to consider geographic locations. So now it's quite common for us to have a mix and a hybrid, and that's been really, really helpful in my opinion. When considering this, obviously you've got to discuss it with the other side, and you've all got to come to an agreement as to how it's all going to happen. But in terms of when we're dealing with it and thinking about what's most appropriate, the main thing for me is considering what's appropriate for you and your client. I personally feel that as much as it's not a one size fits all, most of the time it's helpful for me to be in the same room as my client. I feel that you get a bit more of an understanding of where they are, and you can share the same documents, and it's a bit more, it just works a bit more seamlessly that way. But it doesn't mean to say that it can't happen when you're in different locations. But it's often a bit of a hand-holding exercise as well, which I find really useful to be in the same place. But as I say, I have done full remote mediations, which have been really successful. So you want to consider that and talk to your clients about that. Talk to your clients about how that will work. And most of the work that we do is with our clients in the room, with them on their own or with the mediator. So I don't know whether Richard might have any more points to consider on that.
No, I think you hit the nail on the head. I think that it was everyone probably remembers who's been involved. There was 6 months or so everyone was getting to grips. Now I think almost the decision is almost the default, almost as hybrid or remote. And then I'm finding that actually it's more of an exception now when someone goes, actually clients would really like to have an in-person mediation because it's of the nature of a dispute. And what's beautiful about the remote or hybrid model, especially the hybrid, is there's only 2 points. One is, what do we need to organise as between the parties? It's very quick to all agree remote. Most mediators now, even some of them, are doing different prices for remote, which can be easy. And it means also that if you have got a client, they can, as between you and your client, you can change your mind at will. But as Sophie said, I would always, remote is fine. We've had very successful remote mediations, but more recently, certainly hybrid. And I'd always say to clients that we're not going to incur the costs of mediator traveling. We're not going to incur the costs of having to find a room, rooms in the middle of London, or arguing about which offices to go on. But I would always say that whether it's us traveling to you or you traveling to us, that is a cost that's probably worth it. Because as Sophie said, astutely, that most of the vast majority of the work is done in your room, not really with the other side. And really, the mediator being in the room is easy to do remotely. It's having your client on the other end in the middle of Scotland over a computer. It's probably not ideal, but it can work.
Yeah. So and then the final point for me is when do you mediate? Well, ideally, you want to mediate at your strongest point. Obviously, as I touched upon before, that can be pre-issue or during proceedings. But in terms of, where you are, your strongest position, that is different for people, for claimants, for defendants, and it might not be the same. You might not be agreeable. You might feel that it's appropriate, and the other side might not, and you obviously need to navigate that. Various things that you want to consider as to when it's appropriate to mediate is, how much information do you have? Do you have all the information about the assets in the estate? Do we have valuations? Is that going to be readily available when you go to mediation? We don't want to attend mediation and it not be worthwhile, and we actually realize there's a whole host of other issues that cannot be resolved on that day. And I know that Richard's going to come on to that point in terms of making sure that you are capable of reaching a settlement on that day in a bit more detail later on. But it's important to kind of look at those, because this isn't just a tick box exercise. You don't want to waste, or well, certainly shouldn't be, and you don't want to waste that opportunity if the matter is capable of settlement. And if you suspect that mediation is the best way to resolve your case, then you need to be careful in terms of starting your negotiation already in correspondence. The mediator and everybody obviously will have seen that, so you've kind of already set your bottom line, you need to consider that from a tactical perspective. I don't know if you had any more points to make on that, Richard.
I think that final point is really important. A lot of clients, the concept of trying to settle through inter-party correspondence is fantastic, and there are some cases where mediation may be cost prohibitive. But I think you've got to be very careful, because no matter what anyone says or what you try and then say in your position statement, the other side are likely to take your most recent offer as your starting point. And you can say all you like, or well, this has all been rescinded, we're going back to square one, and don't assume X, Y, and Z. But they will know that you've already offered this. And also you can end up doubling money. So whilst in theory, if you have a quick negotiation through inter-party correspondence and then draft the settlement deed or whatever it is, in theory that sounds attractive and you'd save the cost of mediation. But without the pressure of the mediation, the day of the mediation, without the pressure of the mediator, quite often there's no bite or pressure on the parties to do a deal. And so you can end up wasting months going backwards and forward, and then having to mediate anyway. So if you make that assessment, I would always say quite early, and even it's not to ignore offers if they come through, if there's a genuine prospect. But I do think that if it's likely to end in mediation and it's in a state that would benefit from it, and I would be very hesitant at going in and starting inter-party negotiations at a point where, if you're going to mediate, they will then see that as your starting position, where you may well not want to do that. But other than that, thank you very much, Sophie. We will jump into now preparation, which is, I think, possibly the most important part. And I'll start with the 6 Ps, could be 7, but it's far too early to be swearing. The proper planning and preparation prevents bleep poor performance. This couldn't be true in mediation. The goal, in my opinion, has to be to end the mediation, if you can, with a legally binding settlement. I don't buy the idea at all that you would mediate and waste that chance just to see what the other side are going to say, or to try and narrow the issues. there are a host of ancillary benefits, as Sophie said, so I don't think mediation is ever wasted. But realistically, you want to go with a view of settling it on the day if you can. Sometimes cases are going to be too complicated, but otherwise, failure to achieve it on the day is often due to lack of planning. So people turning up and not knowing things that they probably should do, finding out that the parties who need to sign the agreement aren't there, so you can't do it. Council, dare I certainly deciding that they can't possibly, advise and do that on the day, so we'll do it later. Those kind of things, are things that you can try and avoid. If you know that there are cases where you're going to have to try and sort it later, it could be if there are minor beneficiaries, it could be because you're dealing with a complicated estate, farmland or whatever it is, and you know full well that the likelihood is the best you're going to get is an agreement in principle. That's fine. At least you're going into the mediation knowing that the parties are probably going to have to take some tax advice together, or the party, the mum and the mother and the children are going to have to take some to negotiate a secondary deed because inheritance that claim or something of that nature. That's okay. But what you don't want to do is turn up on the day hoping to settle it and then be blindsided and find out that you can't. And again, I've finished with fluffy heads of terms and this idea of, oh, we'll just note it down, it's fine. I often end, it's very rare that it will fall, it's rare still that it falls apart, but I've had two mediations that settled in principle on the day. Legally, they could have been sorted on the day. We pushed for it continually along with the mediator. The other side refused. And of course, what you get back is, oh, no, it's fine. We'll do it. It's top of the list and so on. And then, in both of those cases, it was months and months before the final documents were signed, because as soon as the mediation is over, council's then gone, other work starts taking over, people can have, buyer's remorse, start, opening things up again. So you want, if it's all possible, if it's settleable on the day, that's even the word, you want to try and do that and avoid it. If it isn't, at least do it and know that you're going into it and know that you're likely to have stages and that the best you're going to get is here. In terms of one of the key things to think about is who needs to be there, or at least who needs to be available. This can come up all the time, and it's highly frustrating if you're someone who wants to try and get it sorted. But people often frame this question solely on the basis of proportionality, and proportionality is obviously very important, but it's more important in my opinion to focus on who actually needs to be there to reach a legally binding settlement on the day, and who might need to be there for information. So there's two parts. Do you need any information? Who needs to be available? That might be, it might be disproportionate, for example, for the executors to be at the mediation, but they should certainly be aware that the mediation is happening on this day, and that the person who's been dealing with the estate, for example, should be available on the telephone all day. And again, you can't rely on someone just having a free calendar. That needs to be in place so that if you got any questions that you couldn't resolve before they're available, it's not always obvious who needs to be there. You could have a probate claim, for example, being brought by one brother, whereby if that brother succeeded, the sister would have an equal cause of action. They might not be aware of a claim, or there might be a risk that they could find out. Do they need to be there? Does this brother need to have a form of authority? Ought you to be mediating with both of them? Because you're going to say, look, I'm not going to settle this claim over here with, potential claimant with the same cause of action on this side. So you've got to think very carefully about those things. It may also not be a legal point. So, for example, if you're doing a deed of variation, we all know that the beneficiaries all need to sign it. But what about what if the other side has a particular desire that the executor has to sign it, even though technically speaking they don't? You may have someone who goes, no, we want the executor to sign it. It all needs to be sorted out. We need to be pushing those things and finding out at the beginning. And one of the things that comes up more regularly now is that there are quite a few discretionary trusts, because there's been which is a topic for another day, seemingly a bit of upselling on relatively needless discretionary trust options sometimes. So you'll get even quite simple estates where you've got you've suddenly got a trust involved. Now you might take the opinion as the claimant, well, you as trustees are the only people who matter. You can bind the trust to a settlement, and great, let's go mediate. The last thing you want to do is then turn up and they say, well, no, we can't possibly do that. It's far too risky. We're not signing anything today. We're going to have to go back to the beneficiaries. So, you need to raise this early and say, we think this can be achieved. We think you can bind the The trust to a settlement. Do you agree? If not, what do you need in place? And let's get it done. Do you need a form of authority? Do you want the conditional beneficiaries available on the day? If so, let's get that in place. Or can they be in your room? These are the kind of things that you need to sort of think about. Same goes for ring fencing. And when I say minor beneficiaries, I mean that in both interpretations. People who are pecuniary legatees, for example. Don't assume on the day that item 1 is going to be, oh, let's just ring fence this 50 grand. Have that discussion early and say, look, there's 10 pecuniary legatees all getting £100. Can we agree, for the purposes of mediation, that that's going to be ring fenced? Those are the kind of things you want to think about earlier. It may be that you don't want to agree it, but if you want to, let's get it sorted. Minors, if there are children involved, even if you ring fence them, if you look at CPR 21, it's pretty unequivocal that you're going to need approval. Your opponent may think differently, so it's better to have those kind of options. And again, if you need a form of authority, get it in place. Let's have a look at it before the mediation. Make sure the mediator's got it so that you're not messing around on the day. We're finally getting down to settlement, but the person you need to actually sign it isn't there. Continuing, you start with the end in mind. How are you going to code? This is probably the best technique, I think, for making sure you're not caught out, is that how are you going to codify and structure everything? When you start thinking about that, it really does bring up things that maybe you might have forgotten about. You're so bothered about trying to prove, that so-and-so wasn't unduly influenced, or that, that kind of thing. You might forget, well, hang on a minute, if we actually get a settlement, what are we going to do? Can we do it? Do we think about lump sums? Do we want to look at percentages? Is this the case where life interest might be included? And if so, how are we going to do it? Are there other potential solutions? But also the other things that can at 4, 5, 6 o'clock in the afternoon, you don't want to suddenly be thinking, oh God, there's a caveat, or maybe at 2, what the numbers, when were they supposed to go out? When did they lapse? Have we got, we've got proceedings, we need to do a Tomlin order, or have we issued proceedings not served, and perhaps we need to do a note of discontinuance? That's got an automatic cost provision, so that maybe we need to disapply that. Chattels, often they can blow up things at the end if you've been talking all day about a property or various assets, and the client goes suddenly at the end, oh, by the way, grandma's piano is the most important thing, and if that isn't part of a deal, it's over. And so on that, we've got to be careful about making sure that you thinks at the end. No one knows what the settlement is going to look like, but you can certainly have a start with the end in mind. And again, thinking about mechanisms. Is there a house that needs to be sold? Is there land that needs to be marketed? If people need to move, are there things that need to be shifted off the land? All these kind of things you need to have to think about, I think, before. And that might dictate how you approach it. It might dictate what you talk about from clients. Tax, massive. Anniversaries, 2 years from date of death being an obvious one. Does it need to be a certain way because you might be giving away, if you do a settlement agreement, is there a danger that you might potentially have a potentially exempt transfer that becomes chargeable? Are there problems with inheritance tax, CGT? Do you have, if your client gets a massive lump sum, are they going to lose benefits, and have they considered that? And are there mechanisms that are going to force your hand, or at least you want to be aware of? And again, other interested parties we've touched on, is there anyone you need to look at in terms of confidentiality, in terms of, a deal that you need to have other people involved, and all the way to the end of simple things. If you're going to need a deed, it needs witnessing. Can you do it on the day? The last thing you want to do is get printer issues at the very end, which I've seen before. You can really derail things and take absolutely ages when it doesn't need to. And finally, just repeating what I said before, if it can be settled on the day, that has to be your goal. If it can't be, at least be aware of that before. Try and understand what bits, so that your client as well can understand what you can achieve. So if you need to do that, if it needs to be split into different ways, at least have that borne in mind. What don't you know? So don't be caught off guard by things that you don't know or that you need to know. I think Sophie touched on this before. One of the biggest things is valuations. So if you don't know, if you need to know a valuation that's really relevant, don't go into the mediation not really knowing, or sort of your client being unhappy with it, or that kind of thing. Obviously, it's a voluntary agreement to mediate, and you have to balance what the other side will and won't do, and how much you can force it, and so on. But just bear in mind that, you know, no one can understand a concession if you think a property is worth $1 million and the other side thinks it's worth 500,000. You might think you're giving away a lot, and the other side thinks you're giving away nothing. So don't, you know, if you think you need to revalue something, if you think that something's changed, make sure you have a look at valuations. Further evidence, could it make the difference? You know, mediation has an extremely high success rate. It may well be that that medical report that you possibly weren't thinking about, but you were definitely going to do if you litigate, that could be the difference. And I'll go on to how that can help the mediator. Tax again. Do you need tax advice before? Do you need to properly understand how to use a spousal exemption if you're there? Do you need advice? I took some advice recently on how it worked with the Department for Work and Pensions things, and what we could and couldn't do potentially, and how lump sums and other things affected it. It may be that you can't do anything, but you don't turn up on the day and then suddenly go, oh, I wish I knew what to do here, but I've never even thought about it. And I think the final thing really, other than, of course, as Sophie touched on, you know, if there's anything else you think you need to know, get that, you know, solidified. One of the biggest things is what's actually in the estate. And I don't, you know, and you know, quite a few people here may be work in an uncontentious world, and you'll know as much as I do that what draft estate accounts or even final estate accounts tell you isn't often what, you know, everything you need to know. They can be quite theoretical, especially for the purpose of mediation. It's not always easy to tell what has actually been sold, what has actually been gathered in, what liabilities are still yet to pay, what haven't been paid. So you've got to have a really good understanding, I think, almost childlike. And sometimes I'll go back in quite an annoying way and say, look, sorry to be not particularly bright on this, but can you just tell me what has actually been paid? What are you physically holding in cash? What, you know, is this, you know, lump sum hypothetical because actually nothing's going to be sold? So that's one of the biggest points, is getting to understand what the net estate figure is, because if you can't agree, on that, you don't understand, or the other side turn around and say, well, actually, there's no cash because, of course, that's all been used on the inheritance, and we can't sell this property in Austria because we haven't got this. You might think you're dealing with a, you know, £2 million estate, but in theory, or in actual fact, there's no cash at all. There's a property that's really difficult to sell, and the other side are going to turn around and say, well, what do you want me to do? So, you know, that's a key. And then looking at the run-up, and I think Sophie might have a couple of points on this, if not on something else, but you know, managing the clients, especially on costs, because especially if you're a claimant more than a defendant, possibly even both, whatever you receive is going to be net of what you've already paid. So the client needs to be understanding of that. You know, being available, it's a really stressful thing for people to go on. It's easy for people who do mediations a lot to forget that. You know, it's same as if you go into hospital for a nurse or a doctor, that's run, you know, day to day, but that might be the one experience in their lifetime for mediation. And the key thing, I think, is to don't wait to have those difficult conversations. You need, you know, fighting hard and being tough with the other side and getting a good settlement is not the same thing as telling a client exactly what they want to hear. And the worst thing you can do is not deal with the reality of the case, get to the mediation and suddenly start telling a client about the difficulties and the cost problems and whatever. And on the outside, when you're dealing with the opposition, I always say take control and try and be proactive. You know, it's a voluntary process, and what you want to try and do is make it as structured as you can, so that you're not blindsided, or that you've got at least some trust with the other side. So, you know, seek to set the tone if you can. You know, agree a mediation timetable if you can. You know, get mediation bundle index out a week then to comment on it. You know, bundles. When are we doing the position statement? Do we need to have a set date that avoids being that takes away some of the risk of being sort of hijacked? So do we say, you know, can we agree that any additional evidence is submitted by this date? Of course, the opposition may ignore you, but at least you've set it out, you've tried to manage it, and then you can refer back to it. And then, you know, thinking about briefly on the position statement, I don't think it's ever a particularly good idea to have any sort of red lines or things you're not going to do. But mediation position statements are probably for another day. Sophie, anything on this part, or?
Yeah, I was just going to mention that I probably should have, it's probably for a few slides ago, to be honest, but just in terms of when you're doing your preparations for mediation and you're looking at the mediator and your choice of mediator, also just to consider, you know, what type of mediator you want. I mean, obviously you've got to agree with the other side, and sometimes they can be a bit of a barrier there, but you know, certainly within our team, we would ask each other if we've had any experience or know people who've had experience of different mediators, because they often have different styles, different techniques, and you know, you might need a particular type of mediator who's going to help both parties, not just always, you know, your client. You need them to be able to help all the parties get to, you know, the same point and reach a common ground. Obviously, and sometimes it's useful to talk to the clerks and say, you know, what about the mediator, about their style. And then this is probably a really obvious point, but one that's worth mentioning is making sure that the mediator who's instructed has, you know, is a specialist in this area, because I've had it recently where I've had some people on the other side trying to push mediators who just don't have the relevant expertise, and that's just going to, all that stuff that Richard's just talked about, the valuations, the tax complications, all the stuff that you need to prepare, the mediator needs to be able to deal with those points as well, because they're the ones who are going to be, you know, reiterating it to the other side and saying, well, what about this point and what about that point, and have you thought about it from this perspective? So yeah, and just as I say, probably quite an obvious point, but one worth just mentioning, that the mediator is really important, you know, obviously in mediation. So just to consider them and their credentials really when you're choosing who to appoint and who to.
That is a really valid point, and I think it's always a balance between not being pedantic and having to have your suggestion, but at the same time you do need someone who's going to, you know, all you should care about really is has this person got the gravitas, experience, and know how to settle the case. And it doesn't necessarily need to be someone that you've worked with before, but it needs to be someone who actually specialises in what we're doing. Yeah. On the day itself, I'll rattle through this because I'm aware of time, and Lindsay's projecting a look of concern at the length of time that we are waffling on. On the day itself, this is purely an opinion. Joint sessions I've never been a big fan of. Some people like it. I think it often ends up with people like me and Sophie trying to grandstand in front of clients, the person on the other side doing the same. It can then take 2 hours to calm down. I've had a couple recently where mediator who's very experienced, was quite keen on the idea. It didn't set the mediation back too much, but again, even the ones that were sort of quote unquote pleasant, one of them just resulted in the other side talking about their profession and how accredited they were. And the other one, the clients came back and just decided that she looks, and the lady on the other side was definitely capable of undue influence, and now she'd seen her. That was it, and you know, that's a couple of hours to wind down. So I've never been a big fan. It can be a long, clients need to feel heard. Often a good mediator is going to do that for you. Taking Julia Burns, for example, she might do a conference beforehand, and Sam Lowe and others will have a good chat at the beginning. It's really important because for them it's often about their father or their sister or so on. You know, who goes first? Does it really matter? No, not to the extent that you would create an impasse for no reason, but of course if you're it may matter in terms of if there's been an offer before, then perhaps that other party, it's natural for them to respond to it. If there's a claimant you're not really sure what on earth they want, that might be a useful one, but it should never be something that becomes an argument in itself. Initial questions, again, costs, try and get that out of the way. If you need to know the other side's costs, if you're not sure what they've said in the position statement, or if you think, well, hang on a minute, what's this third property in the Bahamas that we've never heard about, better to get that out the way. First offer doesn't need to come at 2 o'clock. There used to be this weird thing where you would talk all morning and then an offer would come in it was always around 2 o'clock. It doesn't need to happen, and I know mediators now are much better at that. Fresh air and sugar, never underestimate how important keeping sugar levels up, making use of those breaks. If you've just put a difficult offer to the other side and it's lunchtime and everyone's looking a bit scraggly, get outside, have some lunch. And Sophie, I know you've got some experience of fresh air and how important that is.
Yeah, we actually, it was a result of a joint session once, and there was a couple of comments that my client particularly took issue with, and it just kind of derailed the kind of quite positive way that we'd approached the mediation. And it meant that for the first kind of half of the day, my client was just not budging, to the point where we were all quite worried that it was just a bit of a waste of time and we weren't going to get anywhere. But yeah, it's amazing. We ended up just saying, right, let's get out the room, go for a little walk, have a chat, you know, get some food. And even just a different environment, it often can make a big difference with your client to kind of see things. And we came back into the room and it helped, and actually was able to think, right, well, potentially we're going to walk away from this having not got anywhere after all this prep time. Yeah, so that was really helpful. So definitely don't underestimate the some food. I think we had some decent brownies as well, which helped.
I think you know, so much of a successful day, which is why I think it's important to your room with your client. Mediation is all about, you know, trying to get to that bit. If you imagine two elastic bands, they're trying to get to the middle, and that bit is going to be difficult, and you're trying to get them to touch. If your client is focused on what the other side are going to get, it's going to make it very, very difficult. You see, you've got to try and get your clients to think about their side, their risk, what they get out of it in their life going forward. But at the same time, you might know where it sort of might end or what the landing zone is, but you've got to let your client feel the drama of the day, because it's often the drama and the pressure of the day that's going to bring people to make decisions that they might, you know, they wouldn't make without any of the pressure. And that was something I had to learn, you know, seeing people upset, or, you know, that's okay, and to sort of manage that and help them through it. Final point on this one is just to get, sometimes you can get a sense of where the challenge is. Mediators obviously can't tell you what's going on in the other room, but they can certainly give you hints sometimes, or you can pick things up about, is it, you know, is it counsel led, is it the partner of someone the other way, and that might help you with how you approach it. Just quickly on this, because we are running out of time, do help the mediator. Had a really good chat with a mediator recently on 2 points. If you're going to say something, you know, I know it's a flippant comment, but going back to valuations, you know, that house is worth £2 billion and you know it, you can ask the mediator to send that forward. But if you haven't got anything to back it up, it's not good, you know, mediator's not going to be able to say much. So if you want to say it, do help the mediator by producing something that she or he can actually take to the other side. Biggest thing, I think, and it's a big gripe of mediators, don't force a mediator to do the hard work for you. This comes up quite a lot, or the complaint does. You've got to have those difficult conversations with your client about law versus morality, about costs, you know, what's a good, a bad, a worst case, best case outcome. What happens if we don't settle? The amount of times someone says, well, it's fine, I'm leaving, I'm going to go, and they go, and they've forgotten about adverse costs, or they decide that they're just going to be, you know, go to court and it's all fine, and the worst that happens is nothing. You know, you've got to, often they forget, and you've got to be there to remind them, well, no, this is really difficult, but the worst case isn't just nothing, it's that you might have an adverse cost order to $200,000 and you need to work on that. And quite a few mediators have said to me that, you know, some solicitors will let them do that bit. And of course, what happens is that the client then feels like the mediator isn't on their side, because the client's only heard for the first time that there's a possibility that they might not win. So you've got to help the mediator. Brief word on tactics. It's amazing what the people really want. I've been at mediations where everything started around someone staying in this property, and sometimes you can, if you flip that a bit later, we ended up with an outright sale. And that person was absolutely, you know, I'm going to be in a box before you carry me out of this. Absolutely no way. This is my life. And of course, then you get into other ways of looking at it. And it was solvable. Anchoring, slicing, there are lots of approaches how to do it. It doesn't need to be £1 million, £1, 900,000, 100,000. You know, you can make an offer and anchor yourself to this sensible offer. It can cut to the chase. You know, things like that to consider. But you know, I won't go too much into that. Don't try to avoid tunnel vision on structure. It's very easy to get into lump sum here, lump sum there, or, you know, there are other ways. Always look at other ways to do it. But at the same time, if you're changing a landscape, and sometimes you know recognizing an impasse, you do need to talk at the same level. So if someone's coming at you with an offer and then you're starting a counter offer in completely different scenarios and figures and all sorts, is very difficult. And recognizing you might need to change the landscape, and if you're at an impasse, sometimes that's the best use of a lawyer session. I've had one where it was no point doing offers because the legal side was so odd that actually we unlocked it by having a session saying, look, if I believe you in your case on X, Y, and Z, all I can get to is X amount. So your client's asking for sort of double that. So I'm really struggling to see, you know, where, and that actually unlocked it. And it's obviously not a deal at any price, with this sort of final thing to say, that you know, it just because we want it to succeed. If it's not right for the client, it's not right. But what I would say is that has to be a rational decision made by a client, and you're the best judge really, or they're trying to help that to make sure that if they are going to pull the plug, that they understand what happens next, they understand the consequences, and that you're managing that, as opposed to it being an instant reaction when someone spent 2 hours in the other room to move £10,000. Very quickly on the end, it's one of the hardest parts. And I think what I would say without going into this is, if you thought about it, if you planned in the way we've sort of talked about, if you thought about settlement structure, if you thought about all the things you need to tick off, it's going to be an awful lot easier than being 10 hours into a mediation, being at your most tired, and then suddenly having to try and draft and think about things. And on a final point here, thinking about genuine risk and versus sort of being a pedant about things. Sometimes you do need to hold fire on something. Sometimes, you know, it can be absolutely pointless, and you're just sticking to it for no reason. What can make it particularly harder? Just finishing up, sibling rivalry can add some complexity. And before we get to questions, I wrote an article a few months ago, which I think went down quite well. It was interesting just on the type of things, why it makes it so difficult. And it's again purely opinion, but you can often find in sibling rivalry cases that they can adopt what I'd call a sort of scorched earth policy, or a policy of mutually assured destruction, and all they care about is the other person not getting something. And it makes it incredibly difficult, because you are constantly trying to fight that against, you know, but don't lose your house and the money that you've been given in the will, just trying to stop them getting some more. And some of the themes that could be present, and then present in often in cases, are things like, you know, the surviving parent may have a very different view to when the parents were together. Geography is always interpreted differently. Often the sibling that lives closer has the greater care burden. The other person is seen as the person who's flown the nest and doesn't particularly care. Sometimes you've got to deal with those kind of issues. The care burden, all that brings up often things about who's more deserving, you know, which can be anything from, I've cared for mum longer than you have because I live near her, that's why I'm more deserving, or you married into wealth and you're not. You know, shared history, the amount of times in the mediation someone will say, I know they're only making it after because they're being tactical and she always was like this. And you know, historical grievances with different people, the way they look at things, people believing that they had the inside track on what mum and dad really thought. And of course the weirdest one, which is why it can be really difficult, is that often if a mediation is actually looking like it's going to settle, this might be the last time that anyone ever has to talk to each other. If that linchpin, which is a mother or father, goes, and the siblings know subconsciously they may never ever speak to one another again. And on that, you can sometimes find people trying to adversely hold on. And on that basis, will any of these issues, barring potentially some points about care and so on, be solved in litigation? And often the answer is no. And therefore, litigation is not going to resolve some of these issues. And let's keep control, therefore, with a settlement in realistic terms, and not let you know, hatred or, you know, sibling rivalry get in the way. Apologies for rabbiting on far too long. I'm not sure we've got much time for questions, Lindsay, but I'll let you.
I think yes, we can do a couple of questions. Kat Moody wanted to ask a question. You can unmute, Kat, and speak the question, or you can pop it in the chat.
Oh, hi, it was just a question. Can you hear me okay?
Yeah.
Yeah, it was just a question about costs, really, and I wondered what your views were on in respect of mediation costs, and in particular, I'm looking at it from more of a contentious probate mediation, and whether you would expect each beneficiary to pay for the mediation, or it to be paid by the estate, or just kind of getting a general feel as to what you thought would be the usual approach. I
think my view would always be that obviously the costs, your private costs with your solicitor, are going to be between you and them, and that the key thing from my point of view is a client always understands where they are in a particular phase, how likely it is, you know, what the costs are going to be. And those will never really be shared by the estate. And of course, when you go to a mediation, you're never sure quite what contribution you're going to get. In terms of things that, if you're talking about who pays for the mediator, who might pay for rooms, I do think there are occasions where it makes sense for the estate to fund that. But I think the default position is that the parties pay equally. And if you've got 3 parties, the default position normally would be that each party pays a mediator. There are exceptions. I would always probably go down the line of the assumption would be that the parties split the cost. The exception would be the estate pays for it, and I would never start with the assumption that the estate should automatically pay, especially if especially if there aren't any particularly good reasons for it. And
yeah, that's great. That's the answer I was hoping for, to be honest. So no, that's good. Thank you.
Right, so thank you for that. That was really, really interesting. And as mentioned, the recording and all the notes are going to be on the IDRN. So just with the IDRN in mind, I just wanted to quickly share my screen and show you some of the key features on there, if that's okay. So can everyone see that okay, Richard? Is that okay?
Yeah, sorry,
yeah.
I can see.
Yeah, okay. So just wanted to give you a bit of a show around some of the key features and what's coming up in terms of events. And I thought it might be just a little bit better to get away from the slides for a bit, have a bit of engagement, have a look at the actual website itself. So as mentioned, I'm sure quite a few of you have subscribed already, but if not, please do so. I've just popped the link in the chat. It's completely free. The IDRN is our free online referral and support space, and it gives you all the information should that contentious case land on your desk. But it's also got tons of other resources on there. We've worked really hard as a team to get all this content up, and it's great for just general browsing with regards to wills and probate, and not just contentious issues. So just wanted to point out our triage area. So this covers off our most commonly occurring cases that we get. So we've got 4 of them up there. So we've got the disappointed beneficiary, caveats, lot versus nugus, executors can't agree, and charity will legacy challenges. So basically each area covers off what you should do with one of these. Basically, if you come across one of these in your day-to-day, quick guide on how to approach each one, and then just basically signpost you to different areas within the IDRN, so different articles, FAQs to help you just navigate that claim. And if that claim just becomes a little bit too much, then we've got a fast track a client area. So the fast track a client area, it basically provides flexibility when sending over any clients that you have with contentious issues. So you just simply complete all of their details in here. You can also add any case information, so it's easier for us to understand the problem. Basically, that all that information goes straight to our triage team, and they will contact your client within 24 hours. As you can see from the sidebar, there's absolutely tons of information on here on various different topics. You can also, there's a bit of fun here. Have a little bit of a go on our quiz if you've got a chance. So just going to head over to the event hub to let you know what's coming up. So next events we've got in June, we've got an event with Paul Smith, who's a financial abuse specialist, and one of our partners, Cara Huff, and they'll be talking about elder abuse. So that's coming up on Wednesday, the 14th of June. So you can register your interest there. And next event for July after that, Eleanor Stenson, another one of our partners from IDR, will be covering off the Inheritance Act 1975 and any pitfalls or benefits when registering one of those types of claims. So to keep updated on all this, please do just register. If you haven't registered already, as mentioned, it's all completely free. Right, I'll stop showing my screen. So I think that wraps everything up there. If anybody's got any more questions or anything like that, please do email me or Richard or Sophie, and we will get back to you. But as mentioned, if you've got any colleagues who have missed out on today, get them to subscribe to the IDRN, and all of the information will be uploaded on there. So thanks again, and we'll see you in June, hopefully.
Thanks, everyone. Cheers.